Hi, this is Kate. Just before you listen to this next episode, I wanted to let you know about an opportunity with Amicable. As you may know, we're thrilled about the upcoming historic change in the divorce law, and I know that for many of you too, this has been a long time coming. So if you are waiting for the introduction of the no-fault system, and you're happy to share your story with others, then please get in touch with Amicable today. We're looking for couples who are happy to talk to the media about this seismic change in the law. Please contact us no later than the 24th of March using the email address hello@amicable.co.uk. Thanks very much. Enjoy this next episode. Welcome to the Divorce Podcast, a podcast that aims to address divorce, separation and co-parenting here in the UK, countering the often sensationalist way it's portrayed in the media, challenging the status quo and driving for reform. On each episode, I'm joined by experts to discuss divorce, separation and co-parenting from different angles and to give their opinions and to debate them. I'm Kate Daly, a relationship counsellor and divorce coach, co-founder of Amicable, the divorce services company, and host of this, the Divorce Podcast. In this episode, I was joined by Hatti Suvari, the CEO of Red Bar Law LLP and the founder and host of the very popular Get Legally Speaking podcast. Hatti's podcast focuses on making legal knowledge more accessible to ordinary people, and we began by unpicking the upcoming changes in the divorce law to the new no-fault system, which will be introduced on the 6th of April. Hatti explained how the current system often requires one spouse to blame the other, unless they're prepared to wait at least 2 years and both agree to starting the divorce. We discussed why having to blame each other from the outset makes for some tricky negotiations of finances and children arrangements. We explored the common myth that unreasonable behaviour or adultery has a bearing on financial settlements, when in reality this only impacts a financial order in very extreme cases. Hatti talked about the change in terminology that should make divorce more accessible, as people may feel more comfortable navigating the divorce process by themselves. We also looked at potential criticisms of no-fault divorce, and Hatti addressed the fact that divorces will take longer. We both agreed that this isn't necessarily a negative, particularly if you have financial and children arrangements to make, as allowing time for your partner to adjust to the change can make negotiations less stressful and of course less acrimonious. If you really loved this episode or want to hear more episodes like this, then please make sure to rate us on your preferred listening platform. Enjoy the episode. Welcome, Hatti.
Hello, Kate.
Hi, Hatti. It's lovely to see you. Thanks so much for joining us. Now, I should say at this point, your podcast is all about lots of different legal issues, but today we're going to focus on divorce and specifically the law that's changing in no-fault divorce. The current divorce laws are due to change on the 6th of April. Instead of having to give the court a reason why your marriage has broken down, you'll now have to wait for a period of reflection time only instead. This change is known as no-fault divorce. Hatti, what do you think people need to understand or need to be aware of about the new law coming in? What are the key changes?
Yes, I mean, the 6th of April is going to be a key date for all of us. We'll see the biggest shake-up than we have in the past 50 years because no-fault divorce will finally be introduced. I mean, with the average divorce rate being over 33% in the UK, these changes are much awaited and welcomed. And the Act, actually, for anybody that wants to know, was actually passed in England and Wales in June 2020. So it's taken almost 2 years to come into play. The key change is that married and civil partnership couples in England and Wales can obtain a divorce without having to blame the other party on their divorce petition, and stating that the marriage has irrevocably broken down. That will be accepted by the court as absolute proof that a divorce is genuinely sought. Additionally, big change to the law will be that couples can make a joint application for divorce. A change that basically means that divorce proceedings no longer have to be initiated by one partner alone. And this could lead to a more amicable split if two people say, well, look, we don't have to say adultery, we don't have to say isolation, or you've been, swearing at me, or you're not committed enough to the marriage. But we can say that we're just not getting along, that whole
irretrievable breakdown of the marriage.
Yes, exactly.
Yeah.
And it's more amicable to kind of approach this process as in a joint process. That's the biggest change, I think, as well.
Yeah. Well, it's interesting, isn't it? Because the ability to do a joint divorce now for the very first time is actually quite a big change. And it's not really a change that anyone's focused on, because most of us have been focusing on this idea that you can end the blame game. You don't have to blame each other and things can be more amicable that way. But I guess for a lot of people, it's a much more natural process, because they come to the point where they say, well, it's not your fault, it's not my fault, we've just come to the end of the road. So for those sorts of people, it just feel that there'll be a much better way of being able to go their separate ways and divorce without having to falsely one person blame the other or one person divorce the other. Do you think that's quite an important change for people?
I do, Kate, because in my law firm, what we do get often is people saying, look, this and that has happened, but I don't want to put that on a divorce petition. I don't want to say that, or he or she, my husband or my wife is going to get really angry if I say these things on a document. And, I've been through a divorce myself 17, 18 years ago now, and I know exactly how that felt. And I remember sitting in front of the lawyers and they're saying, yes, but you've got to put something. You can't just put nothing. And I was saying, but how can it possibly be up to a judge whether I should remain married or not? Now, the judge still has to make that decision. But what it means, the law change means, is that you're not going to have to put down all the details, the nitty-gritty details of why you and your partner are no longer getting along. And I think it makes a big difference.
Yeah, I think you're right. I mean, this whole idea that, you don't, when you get married, you don't have to tell the registrar why you love your partner, do you? So the idea of having to tell the state why you don't love your partner anymore just feels out of whack, really, doesn't it? It doesn't feel like it's been, or it is the right way to go forward. So from that perspective, it feels much more even-handed that you can decide and declare the marriage is over and then give the notice period. I guess the other side of that coin is there are some people, and I hear this a lot in the work that we do, particularly where there's been adultery committed, where the person who's been cheated on does actually want to have it recorded that, in their words, they've done nothing wrong. So what do you say to those people? Because that's going to be quite a tough change for some people to navigate, perhaps.
I think you've got to ask yourself why. Why do you want it recorded? And I would say to anybody, again, having gone through a divorce myself and doing divorce in my law firm as, for breakfast, lunch and dinner, if you like, the less contentious you can make the situation, the smoother the process is going to be, because it's already more than likely a very stressful, distressful time. So by saying, well, I want to be able to say it was adultery because that's what it was, I'm not saying you have to go and forgive the other person and you're trying to dress it up in a way that it wasn't. But that's only probably going to agitate the situation a bit more.
So that's interesting, Hattie. So if we're saying that although people might still have those feelings and those emotions, it's actually better for them to take those feelings and emotions elsewhere, maybe to a therapist or somebody to work through that, rather than feeling that the court process, which is essentially an administrative process, needs to be filled up with that kind of emotional baggage. That's kind of a different way of looking at things. So we're not, and you're not saying, and I'm not saying that these emotions aren't important. We know in divorces these emotions can be really important, but the paperwork isn't the place to put these emotions to rest, I guess.
I think one of the other myths in divorces is that people think that if they are the party that's not to blame, then they can potentially get more by way of the financial assets, and there'll be the court may look more reasonable to them with financial settlements and childcare, and that's just not the case. And I think I spend a lot of time saying to certainly my clients, it's two separate matters. The divorce itself is literally annulment of the marriage, or not annulment, ending the marriage, and the finances and dealing with the children are two separate areas even to that.
Yeah.
So, yes.
Yeah, we get the same thing. Just trying to divorce those two things, pardon the pun, is really quite tricky, isn't it? You're right. The reasons for a divorce never or very rarely play into one person getting more cash or more property or whatever out of a settlement than another. So the idea that we don't need the idea of blaming, we can just remove that from the system and just give notice and therefore be divorced in the more simple and less acrimonious way. That seems like a really positive way forward, because you're not starting off on a bad foot then, are you? You haven't got one person, as you said earlier, who's super angry or super upset and then totally unable to navigate the negotiations around a financial settlement. So it seems that this is going to afford people more chance of being maybe more amicable and coming to agreements together and in alternative dispute resolution processes around finances, rather than having to slog it out with nasty letters. Is that going to affect business, do you think?
Well, I mean, except in extreme circumstances, I think it's very important to say that there are some extreme circumstances where behaviour does come into play. Certain abusive behaviour comes into play where one party may get more out of the finances and the assets of the marriage, or access does come into conversation because of the behaviour, extreme behaviour of one party towards another.
Just give us an example of that then, Hattie, because I know, when you listen to these things, people like to think, or not like to think, but some people will think, oh, well, my ex is very extreme. But it does have to be really, really life-changingly extreme, doesn't it, for people to get more money? The fact that your husband is, or your wife is mean to you or is abusive to you, in of itself isn't enough to get a different settlement.
Domestic abuse does come into extreme levels, meaning such as, and I will use an extreme example here, your husband's so abusive, you've had to leave the matrimonial home, you've had to go and seek shelter, and you don't have means and ways to rehouse yourself. You've got young children. You need to be rehoused with those children. Your husband can afford to go and rehouse himself with lesser money from the pot, but you need the majority of the money, let's say 70% of the money or 80% of the money, in order to rehouse yourself and the children. That is a very likely circumstance where a court will say, well, the husband can go and rent, for example, or he can still buy something that will house himself. And was it not for the severely abusive behaviour where you couldn't be expected to remain in the home? And I'm taking out of the equation here injunctions to get the husband down to have the wife remaining. I'm literally talking about where the finances of the marriage will be taken into consideration. That's a situation where a court will likely say to the abused party, or in this example, the wife, yes, we accept that you will get up to 70 or 80% of the marriage to rehouse yourself and the children, or to have your financial needs met for the future. And we accept, because there is enough evidence, supportive evidence, and there is enough here for the court to see that this relationship really ended because of the severity and the abuse that went on.
Do you think then that having a no-fault system will actually make it safer for people who find themselves being victims of domestic violence or domestic abuse?
That's a tricky question, Kate. And really, we have to see how it's going to unfold in court, because if you want to outline, you can't outline the reasons for your divorce, well, how then do you seek such unreasonable behaviour that you try to get more by way of the assets of the marriage? I think time will tell to see what the court's approach is going to be, because at which point do you start outlining that? Is it on the Form E? Is it on the longest court document that I know exists that you've got to fill out to outline the assets and liabilities of the marriage, to say, look, I think I should get 60, 70 or 80% of these assets because this marriage ended purely because of such unacceptable behaviour, and I haven't got the same financial prospects as my partner has, and I should get more out of the pot. I mean, at what point can you then bring it into the equation if you feel that it is a key point and reason for your divorce?
Well, I guess you've got your Section 25 kind of statement, haven't you, where you can put the reasons to depart from a 50-50 in that kind of document. But I was more thinking that it might be safer if you don't have to blame if you're in an abusive relationship, the last thing you want to do is prod the bear. So if you're trying to leave and trying to divorce, then not having to state the reasons, for example, unreasonable behaviour or the abusive behaviour, not having to write that down might be a safer way for people to escape when they're in abusive relationships. So it might be a really positive thing from that perspective. not having to effectively write an accusatory statement to all intents and purposes.
Yes, I mean, there's absolutely that as well. I have known people over the years that have not issued divorce proceedings because they fear for their lives if that divorce petition drops onto the front doorstep of their current partner, outlining the details of what's going on in that relationship. I've known of people like that. So I get that. I get the benefits it can give to that in that situation.
Yeah. I mean, your podcast is all about, removing legal speak, talking in plain language, all of that kind of things. What do you think of the changes? Albeit they're quite limited, but there are some changes and there are a nod, isn't there, towards plainer, easier language. So decree nisi becomes conditional order, decree absolute becomes final order. How do you think that will impact people in terms of whether they'll need to seek professional help or whether they'll be able to do some of this themselves?
Look, I think that legal language forever has been difficult for most reasonably intelligent people to get their heads around. I mean, maybe for you and I who kind of look at it and stare at it and deal with it on a weekly basis, it's a different place. Even the most simple stuff can seem very daunting, and you kind of, as a layperson, because I've done this in the past, when looking at certain legal information, you question it because you think, well, what does that actually mean? And how does that actually apply to me? But I have to say that the gov.uk website, where you can issue an online divorce petition, it's been available since April 2018. And I do find it really user-friendly. And I think, do you know what? I don't think it's, compared to what it was even 3 years ago or 2 years ago in its paper form, I think it's come a long way. And I do think that there is sufficient information online, together with, going on the government website to do your own divorce, to be able to navigate yourself and your way through.
Yeah, I agree. It's really, the system now is very simple, and we had a run through with the Ministry of Justice the other week to see what the new process will look like, and it is very simple and very straightforward. And I would say that
I haven't seen it yet, Kate. So yeah, I'm very interested to see it.
I think the majority of people will be able to do that element of the divorce themselves. And when we sort of talk about divorce, like you say, because we deal with it day in, day out, we're talking about the very narrow bit of unpicking or ending the marriage. When we talk about divorce in more colloquial terms, sometimes we mean all of it, don't we, with the finances and everything else. And I think it is important to separate those two things out. The finances piece isn't changing. You'll still have to make an application to the court for a consent order. You'll still only be able to do that once you've got your what's now called conditional order. So the finance piece is still coming into the same set of forms. It's going through the same process. So you still possibly need some help around understanding what fair means and how you can split your assets and how you record all the different assets that you've got. But I think you're right. I think if you're just talking about the divorce piece, going on gov.uk now makes it very straightforward and simple.
Yeah, no, absolutely. Even during the pandemic, the forms changed.
Yes,
the divorce forms changed ever so slightly, and I remember as we were going through the pandemic, looking at it, thinking, "Oh, this has become easier. This has become simpler." So I do think that it's not so difficult to navigate, which is a good thing. Which is always a good thing.
And what about sort of this run up? So we said, didn't we, at the beginning of the episode, it's the 6th of April when the change will happen. We know that there'll be no divorce petitions accepted after the 31st of March. So there'll be like this hiatus between the 31st of March and the 6th of April when nothing can be sent in or issued. In the run up to the 31st of March, what are you seeing? Are people, rushing to get the petitions through on the old system, or are they waiting for no default divorce? What are you seeing from people you talk to, Hattie?
I mean, in my law firm, I've got one client who is waiting for the 6th of April, and I haven't specifically asked why, but she's just made it very clear, I don't want to have to outline the reasons. And she's been waiting since October last year. So, but other than that, to be honest, I don't think most people are even really thinking about it. If you're going through a really tough time and you're thinking about divorce, as I said, as somebody who's been there myself, the last thing on your mind is the legal process in itself. You're just thinking about the breakdown and as I said, it can be very distressful. If you've got children, it can be even more distressing. and challenging to get through. So I don't really think lots of people are really thinking about, well, I'll wait to the 6th of April or not. As you say, there may be people coming after the 6th of April that say, oh gosh, I wish I'd been able to issue when I could put the reasons down, because they did want to have their moment on the court papers. And there'll be people that says, oh, thank the goodness, I wouldn't have had to think about that. But then when I speak to people, I won't be saying you're lucky because you don't have to put the reasons down anymore, because they don't really want to hear about what was. They just want to know what relates to them, what matters to them, and how does it affect them, really.
There is quite a big difference in the time it's going to take, though, isn't there? So at the moment, you can get a divorce through in about 14, 15 weeks, just doing the divorce without, worrying about a consent order and anything. So people with simple, straightforward circumstances at the moment, it's to say it takes, 14, 15 weeks. Under the new law, we mentioned at the beginning, one of the big changes is you don't have to put the reasons down, but you do have to have a period of reflection. That period is 20 weeks. So when we did our timeline, looking at the current court processing time and the fact that to that 20 weeks, you have to have the 6 weeks added between applying for the conditional order and applying for the final order, you're looking at a minimum of 30 weeks to do the divorce from April the 6th. So that's going to double the amount of time it takes. So how do you think people are going to react to that additional time to process a divorce?
I mean, I don't know about you, Kate, but when people speak to me about divorce, most of the time it's how quickly can it happen? Yeah. Everybody wants things done really quickly. And the first thing I say is we're at the mercy of the court's timetable, because even though we expect a petition to be returned within 3 to 4 weeks, even if you take the pandemic out of the equation and just say, well, that doesn't really exist at the moment, or it never existed, it could take up to 3 months for you to get the acknowledgement of service out. So we're down to the mercy of the court timetable anyway. So yes, everybody wants things done yesterday. My divorce took a lot longer than 30 weeks. I have no idea why. I don't know whether it was because of the time delay in the court system or whether the acknowledgement of service wasn't. But I just think, rather than thinking how quickly can it be done and let's rush through this, just pace yourself, because you're going to need the stamina to get through it, whether you're very amicable, which is rare, or whether you're trying to be amicable but it's challenging, or whether you're at each other's throats. Just try to focus on, okay, if you've decided you're going through the divorce, try to focus on what are we saying in relation to the assets. Can we come to or get some help to come through to an amicable arrangement with regards to the children and regards to financial settlement? It's not going to sit well when you say to people, well, actually, it could have been 15 to 16 weeks, but now it's double that probably by the time we come out the other end. But, I think that people just have to bear with the system, because the court timetable does have a massive bearing on how quickly things are done or not done, really.
And do you think there'll be a surge in applications around the 6th of April? So adding to the potential delays and things, because in other countries, when no-fault divorce has been introduced, we've seen a big spike in applications. Do you think there is some, built up or pent up demand where people maybe are waiting and there'll be a spike?
I certainly haven't seen many clients. As I said, I've got one client who's waiting for the 6th of April and thereafter, but I haven't certainly heard or seen anything that suggests that, Kate. I guess it's just a matter for people, really, but I certainly haven't seen anything that says lots of people are waiting for that time and day because they didn't want to lay all out to bear on a divorce petition.
And when we talk about the divorce process, I mean, one of the things we sort of think about is that this is a positive thing, or I kind of have thought about it in a positive way. Do you think it has its critics as well? The new system, so the no-fault system, I always think of it as a really positive thing, having no-fault divorce. We campaigned alongside Resolution and various other people for this change in the law. But do you think there are some people who perhaps don't find it as positive and who are critical of it?
To be honest with you, with so much that's going on outside of the court system, with the legal system, with what's going on in politics and everything else, I haven't really had that many conversations with people who say, I think that's a really bad idea. The legal system, I think, as I said earlier, is welcoming this change. Again, the biggest changes in divorce laws in 50 years, and I certainly am, because we've had issues where we've had to go to court to actually agree what's going to go onto the petition for the reasons for divorce. So that can't be good. That can't be a good thing, because if anything agitates your divorce process, it will cost you more money if you're getting legal help, or it will be more stressful whether you're getting help or not. And it will take more time, whether you're getting help or not. So it can't be a good thing for there to be any agitation of any kind. And, I've seen cases where I thought, this is going to run really smoothly and be brilliant. And then it's this tiniest little thing that sparks up the agitation. And then we all go off on a tangent trying to resolve that. So I can't see how anybody will be critical of something that will make divorce cost less. Yes, the timescales to get to the end could be longer, or will be longer if you go by the 20-week period of reflection and then the 6 weeks on top of that. But it will cost less, and it should, in all accounts, on paper anyway, literally, create less stress for the parties.
Yeah. And I guess with that 20-week reflection period as well, the intent there is, one, you've got some time to, if you're hearing the news for the first time, to get your head around that. So that always has got to be a good thing, hasn't it? If you've got some breathing space to emotionally come to terms with it. But if it's a joint decision, it also gives you some time to plan and to do the financial work within that period of time. So it may not, for more complicated cases where there are finances involved, it may not extend the time for those people, because they'll be able to use that 20-week reflection period to negotiate their financial or their children arrangements.
But to be honest, Kate, we always say do not apply for the absolute, which is in this case the final order, until your finances are agreed anyway. So I think people have to really take that into consideration, whereby you might want your divorce to happen quickly, but you should really, the best advice has always been, you should get your finances in order and agreed, and any child arrangements in order and agreed if you have got issues with trying to agree those things, before you get the final order on your divorce, or the decree absolute as it's always been known. So in reality, we're talking about 26 weeks, 20 weeks reflection, 6 weeks to get the final order. It would take longer than that anyway if you're trying to get the finances agreed, resolved. And if you're doing it amicably, you get your consent order drawn up, and then everyone signed it and sealed it, and it sits well with all of you. You slept on it and everything else. So I think that the timescales are relevant to any sim, even if it's one asset that you both own and you just need to get that sorted and agreed. I don't think it's a bad thing, the time, because you are getting yourself set up for the rest of your life, financially and emotionally. And I think that time to reflect is not such a bad thing. And without rushing into the decisions, perhaps on the finances or with the child arrangements, because you're, really keen to get out of the other side. If you're separated and you're living separate lives, the end will come through, in the financial sense as well, where you're financially divorced. And I think that everybody should take time to think about that. I have had a lot of clients in the past that have come and said, I don't want anything, give it to him, let him have it all. And I've had male clients have said, I don't want anything, give it all to her, I just want a divorce. And by the time we sit down, we really thrash it out and talk about it and calm down, come back to basics. And I say, well, how are you going to live in the future? How are you going to support yourself? How are you going to support your children? Can you get a mortgage that's going to get you into a house reasonably suitable for you and the children? That's when all the sort of pennies start dropping and people start thinking, oh, well, yeah, you're right. That's right. Yeah, no, I should get my fair share, and that's why reflection has to be a good thing. And I don't think it should be a race against time of how quickly can you get divorced. It should be, how can you both really get out in the best shape you can, spending the least you can on legal fees, understanding your process. I didn't have a clue about my process all those years ago. I didn't know what was going on because nobody sat there and actually took the time to explain, not even my legal team. I was just told, we're doing this next, but I didn't know what that next meant.
Yeah. Well, you just can't see all of it, can you? You can't see the bigger picture. You can only see the next step in front of you. And you're right, actually being able to see the process is kind of really key.
I remember sitting in a boardroom with my solicitor who was doing my divorce, the senior partner of the firm, and I don't know, one of the ladies were in the firm in the room as well. I don't know quite who she was. I was bawling my eyes out because I didn't understand it. I didn't know what was going on, and it was a really stressful time. So time to reflect, and if you don't mind me saying, services like yours, like Amicable, is golden. Because anybody that can take you down from that space of being so upset, so angry, you no doubt have friends or family around you saying, oh God, it's such a shame. And then you have friends and family saying, oh, don't let him do that to you. Or don't let her get away with that. You often hear men, oh, she took the lot. Well, no, because half of one is never going to equals one. So, and you hear women saying, he had the money to pay for all the lawyers and I got left with nothing. So certainly anything that helps your process, and you mentioned earlier mediation, ADR, or anybody that's going to bring some form of calmness to the process has to be a good thing.
Yeah, no, I agree. I think there are lots of changes afoot. No fault divorce is just one of them at the moment, isn't it? I think the whole legal industry is going through a number of changes. And I do think we're seeing, as you say, more people willing and wanting to try and sort things out amicably, trying to stay on good enough terms to co-parent their children. And I think all of us, whichever kind of services we are involved with, if everybody has a duty to try and ensure that we can help people make that transition as smoothly and seamlessly as possible. So listen, Hatti, I'm just sorry we're almost at the end. It's been really fascinating and lovely to talk to you.
Thank you. Lovely to talk to you too.
I'm excited to see what happens with no fault divorce, as I'm sure you are, and hopefully it will make the process better for many, many more people.
Indeed, absolutely. I agree.
And Hatti, if people want to find out more about you and what you do, where can they find you?
Well, getlegallyspeaking.com is the right place for us in terms of our website, where there's over 120 podcast episodes for people to listen to, lots on partnership, marriage, divorce, civil partnership, myths in law, and all sorts of areas. So go over to our website and take a listen to one of the episodes.
That's brilliant. Thank you. And of course, you can find me. I'm on Twitter at Kate_Daly. You can hear about new podcast episodes by following at divorce_podcast. And if you like this episode and you'd like to hear more, you can visit thedivorcepodcast.com and subscribe for future episodes. Thanks very much indeed, Hatti. It's been a pleasure talking to you, and thank you too for listening.